Welcome to U.S. Visa Questions Answered Here.
Welcome to U.S. Visa Questions Answered Here with Immigration Attorney Frances Hayden. For decades, Frances has focused on consular processing of non-immigrant visas at U.S. embassies and consulates worldwide, with a special emphasis on third country national visa processing. I'm your host, Sophia Morales, and today's episode is What is Due Process? Welcome, Frances. I'm so glad to have you back with me today.
Thank you, Sophia.
So we've seen a lot of legal terms in the news recently, and I think one of the ones that's foremost in my mind is this idea of due process. Can you tell us what that is in plain English?
Yes, it's pretty simple. At the same time, it has a lot of different interpretations. It's basically the idea that certain fair process has to be given before you can be deprived of any right.
Okay.
And that generally includes notice of charges against you before you can be processed, appearance before a neutral arbiter, like a judge, and fairness and equality. So
they have to tell you what's going on, give you a chance to state your case and get a ruling, and then they can start to do.
Exactly. The tricky part is the interpretation of the concept, because fairness and equality is extremely broad and means different things to different people.
Yeah. Well, welcome to English language.
Yes.
So where does this concept come from, due process?
Well, it's in the Fifth Amendment,
okay,
which says, as everybody knows, that no one shall be deprived of life, liberty, or property without due process of law. It's also in the 14th Amendment, which is one of the post-Civil War amendments that when the government and the people were very afraid of what certain states were going to do to people's rights. And so what they did with the 14th was they said that also, besides the federal government, the states cannot deprive you of your rights without due process. It actually goes all the way back to the Magna Carta.
Really?
Yes, which was, as you may recall, I didn't, I had to look it up. In 1215, King John of England established the principle.
Yes.
And it's really been adopted, I guess you would say, in kind of a civil law context in many different contexts. Ours happens to be enshrined in those two amendments. It brings up the term that we also hear a lot, which is rule of law.
Okay. And so what does rule of law actually mean?
Really simple. It's basically that no one's above the law.
Oh.
The king is above the law.
That's politically loaded right now.
Very, very politically loaded right now. And I think we were let down in recent times. And the rule of law is in danger. You'll hear many legal commentators saying that the rule of law is in danger. And it would include things that are going on now where perhaps if the president decides to ignore the Supreme Court telling him to do something, that would be a violation of the rule of law, because even the president should have to follow the law and not be above the law. So that's an idea that goes way back, and it's in danger.
Is that currently being litigated right now?
It is being litigated everywhere, not specifically that particular concept, but it's sort of in everything we're doing right now. I guess it would come up in the context of talking about what many people say, which is, are we having a constitutional crisis? And a constitutional.
And are we, Frances?
I think that's above my pay grade. Many people say we are. Yes. And I tend to agree. I think it's beyond just constitutional. We're having a crisis on so many levels. But I would say, yes, we are having a constitutional crisis because the concept of due process and the rule of law are part of the Constitution, and they're both being threatened now.
So who exactly is entitled to due process? Is this just something that citizens get?
No, that's the interesting part. It's very clear in the law that everyone who is inside the U.S. is entitled to due process. And that's firmly established, also under threat.
Mm-hmm. I was going to say, given some of the news articles I've read about recent ICE deportations and seizures.
Exactly.
Yeah.
Yes.
Yeah.
There's a lot of push back on the concept that everybody in the United States is entitled to due process. And that's definitely being litigated. I think that the Supreme Court actually recently reaffirmed it in a decision that they made about the Obregon Garcia case. And they said that everybody's entitled to a hearing before you can remove them. There's different definitions of what due process means that are happening in the courts now. For example, how much notice do you have to give them? Do you have to give them 21 days, 2 weeks, 6 months so that they can prepare to defend in their case? Who is the decision maker? To what extent does the due process have to be followed? This is sort of being rewritten now in the courts and ultimately in the Supreme Court. The concept of undocumented people being entitled to due process is very, very much under threat. They're basically saying that they're not. That if you're undocumented, you're not entitled to due process. Why should you get due process? But most of the Constitution speaks to personhood. It doesn't speak to citizens having those rights. The Fifth Amendment itself says person. It doesn't say citizen. And many, many Supreme Court cases have affirmed this, going back historically with anybody who has looked into this due process for immigrants and non-citizens back to what we call the Chinese exclusion cases, which were in the late 1800s after people from China were brought to the United States to work on railroads and other large projects. Many of them had children who were born in the United States and were U.S. citizens. So the landmark case was this one called Yick Wo versus Hopkins that established that the 14th Amendment due process clause and equal protection applied to all individuals in the United States, not just citizens. And there was a follow-up to that approximately at the same time. So there's a long, long history of the fact that undocumented people have a right to due process in the United States. And it was even reaffirmed in 1993 with Justice Antonin Scalia, who was famously conservative. He wrote, "It is well established that the Fifth Amendment entitles aliens to due process of law and deportation proceedings." So what's going on now with the deprivation of due process is extremely radical.
Wow, this is probably beyond the scope of our conversation here, but what are concerned people doing about this situation?
They're fighting in the courts right now. That's the arena where it's going to be decided, and it's kind of the last bulwark against the infringement on these rights. This administration is actively trying to act as if immigrants, even immigrants with permanent residence, but especially undocumented immigrants, they're just basically saying they don't have due process rights. And what comes up is, even our president in recent interviews has said that, this would be impossible. We have too many millions of people to get rid of. We can't do it fast enough if we give them due process. But the fact of the matter is that it's not a luxury, it's a requirement. You don't get to just ignore it because it's inconvenient. And that's what's being fought out in the court. So, it brings up the question of, does every single person that the U.S. is trying to deport, are they entitled to a trial, which is the word that Trump uses for it? And basically,
what is the proper word for it?
Well, it's interesting because he's thinking, because of the trials he has, he's thinking of the kinds of trials he has that are in either state or federal courtrooms, but immigration cases are decided in an administrative court, which is quite a bit different. I think you and I have discussed previously that the right to an attorney is there, but an attorney won't necessarily be provided for you if you can't afford one. That's sort of up to charitable organizations. So that it has, you have fewer rights, I think, in the administrative context. There is due process in that context, but the standard of evidence and procedures in immigration court is quite different than those, for example, in criminal court. And many people ask then, why are we seeing a lot of cases that are in federal court that are immigration cases if these are decided in immigration court?
Right.
And the reason for that is that if there are abuses going on, you have a right to take it up to federal district court. For example, in the case of habeas corpus, if you're detained asking to be released because they don't have a legal right to hold you. Also, we've seen many temporary restraining orders that are only the federal courts can issue. Immigration court does not have the power to do that. And so, for example, in trying to stop the flights that were taking people out of the country, a federal district court made an order of a temporary restraining order that they could not take that action, which became very controversial because apparently it wasn't followed, and that's still going on. And then there's also permanent injunctions against government action. And so it does get into the federal court, but normally it's an administrative hearing, as I said, with different processes. And if there is a denial of what you're applying for, you do have the right to appeal from within the United States. That's part of due process, that the process continues and you are allowed to go further with your case and take it to the Board of Immigration Appeals. And from there, eventually, you can take it to a circuit court of appeals, depending on where you live, which is the federal appellate level, and theoretically, even to the Supreme Court. So all of that is due process. So the Trump administration doesn't feel they have time for that. They want to meet their immigration quotas, and so they want to push people out without giving them due process. So we're in the process of figuring out what exactly it is and what are people really entitled to, especially people who are not U.S. citizens.
So as far as due process goes, does it make a difference if you're inside the U.S. or at an airport or a border crossing or just applying for a visa overseas?
Absolutely. That is an excellent question. It makes a big difference. If you are inside the United States, you have all those constitutional rights that we enjoy as U.S. citizens, whether you're documented or not. If you are applying for entry to the United States at a port of entry, you don't have those rights. You don't have the right to legal representation. You don't necessarily have the right to a hearing. You can be expeditiously removed. When you're applying for a visa, you do not have the right to an attorney to be present. You do not have the right to appeal a visa denial.
Oh, really?
Yes. There is no right to appeal. This has been litigated extensively by the American Immigration Lawyers Association to no avail. You are still not entitled to appeal of a visa denial, whether it's a non-immigrant visa or an immigrant visa or a green card. There are certain mechanisms that are kind of quasi-appeal-like, but they're not appeals, where, for example, in the non-immigrant visa context, if there's been an error of law, attorneys have a portal where they can write to the visa office and ask for review. That's not the same as appeal.
Right.
Appeal is a neutral judge making a decision on what a previous authority has already decided. It's not that. It's the same exact part of the government reviewing itself. Right. So it's much less desirable than having an actual appeal and more of an adversarial trial-like thing where the truth comes out or not, and then it can be reviewed. Not like that. When the attorney makes the request to the visa office in Washington, D.C., they're basically the lawyers that are studied and working for the State Department deciding what the right interpretation of immigration law is. It's pretty rare to get anything reviewed and overturned. Right. So the only solution for a visa denial is to apply again. Okay. And you tend to have a strike against you when you apply again.
Right, because we told you no once.
Exactly. And so and there's a psychological phenomenon, a human phenomenon, where the consular officer looks at the refusal from his or her colleague and thinks, I don't want to
step on toes. Yeah.
Yeah. So it creates a momentum of denial that when you've been denied once, you're much more likely to be denied again. So it's a very frustrating thing. It's shocking that there is this huge difference, that you basically have no rights. When it comes to deciding who gets to come into the United States, the administration, the executive branch where the president is, and the attorney general by extension, they have a lot of power when it comes to deciding who gets to come into the United States. That's why they say there's no appeal. They have a lot of power within the United States, but they have less. And they're trying now to have the power to treat undocumented people and even some documented people within the United States as if they're outside the United States.
Yes.
They don't have those rights to free speech and due process.
So back to that word due process. If you're in the U.S., and we're dealing with that scenario where you are in the U.S., does this mean that every time they want to deport somebody, that the person being deported is entitled to an administrative hearing, or as Trump would call it, a trial?
Yes, they are. And this has been reaffirmed recently by the Supreme Court and by lower courts, but it seems to be being ignored, which brings us back to the question of, are we having a constitutional crisis? Because it appears that the administration is ignoring in the guise of trying to reinterpret what the Supreme Court plainly said and just not do what they were told to do, which was to provide due process and to, for example, in the famous Obregon Garcia case, to bring this individual back to the United States and then to give him due process before he is either deported or decided not to be deported. He is married to a U.S. citizen. It's really being tested right now. And if it were to occur that people who are undocumented in the United States no longer have the right to due process, that would be a massive change in very well-established law that comes all the way from the Supreme Court. So this is not going to happen easily, and it's a fight that's going on every day, and there's going to be more and more cases that come up to the Supreme Court to be decided about this question. It's a right that's very revered in the United States, and it's part of what many people say separates us from other countries that don't allow that and allow endless detention without charge, allow punishment and the deprivation of rights without a hearing, all those things that we in our culture up to this point have kind of fought against.
Yeah. Do you have a little bit of hope for us, Frances? I hate to end on such a low note.
No. It's a battle that's going on.
Yeah.
And it's fascinating to watch, and I think people should participate and people should educate themselves about it, even to the point of reading some of the court decisions, some of them are very fascinating. There's a big fight coming up on birthright citizenship, as you may have heard.
Yes.
That's another thing that comes from the 14th Amendment post-slavery, that if you're born in the United States, you are a United States citizen. And that came in because people who had previously been slaves who were born in the United States were not considered to be U.S. citizens. And the 14th Amendment was put in to prevent that. And now this administration has put out an executive order to prevent birthright citizenship to certain people who are born in the United States under kind of vague rules that seem to involve the status of the parents, which I think is kind of hard to figure out, like whether your mother was legal at the time or your father was, or what kind of, if they were just on an immigrant visa, then the child would not be a U.S. citizen. And so if this executive order is carried out, then several babies who were born during the time period specified would not be U.S. citizens, as has been the case ever since the 14th Amendment came in. So this case, there has been a temporary restraining order, as we discussed previously, and that has been appealed. I believe it's already up at the Supreme Court, just the temporary restraining order, not the overall executive action and whether or not that can be done.
I was going to say, it seems like they're squaring off directly against the 14th Amendment and going, yeah, no, we're not doing that.
Exactly. A radical departure from the way the 14th Amendment has always been interpreted. So that's another thing to watch. I think it's very important. I think the Supreme Court hopefully will uphold that because it seems pretty clearly part of our Constitution. But there's no way to tell for sure whether they will allow some encroachment on that. Fascinating times from a legal perspective.
It really, really is. Thank you for coming and discussing these important issues
You're
with us
very
today,
welcome.
Frances.
There is hope.
Thank you. I need that.
Me too.
Thanks for joining us on U.S. Visa Questions Answered Here with immigration attorney Frances Hayden.
To connect with Frances and her team, visit haydenlaw.com and be sure to like, subscribe, review, and share.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.